What's up, everybody? Welcome back into the episode of The Lawyer You Know. And today we are breaking down some of the documents filed in Karen Read's civil lawsuit, including her motion to dismiss and the plaintiff's response. And I thought it was really interesting the way this was all reported and how people are talking about this motion to dismiss and what it could actually mean for the civil lawsuits against Karen Read. It's actually not that uncommon. And some of the causes of action that are filed are some of the most difficult to go forward on. So we'll talk about the arguments she has, what it means as far as the timing of this case and what we can expect, and answering all of your questions. I'm so excited. I feel so at home to be in a civil lawsuit like this, breaking it down with you all, my favorite people. Let's get to it. Okay, so we are going to look specifically today at Karen Read's motion to dismiss and the plaintiff's response. As you know, Karen Read has been sued the reason that John O'Keefe died, right? That is what the O'Keefe family is saying. Wrongful death lawsuit, but it includes so many other claims. And those are the ones we're really going to talk about today, which is interesting when we look at a motion to dismiss like this in a civil case. It's not really the same as in a criminal case. They're not going to allege all this wrongdoing and how in the interest of justice, you have to dismiss this. A motion to dismiss in a civil case so many times is like this one. It's technical. And even if you win, the remedy or the response that the other side may have to do is just to amend, meaning change their complaint and refile it, and then they'll eventually be able to go forward on it. So it doesn't really mean that the lawsuit is gone. It doesn't mean Karen Read walks home free, meaning not have to pay any money, because that's what happens in civil cases. You don't go to jail, you just have to pay money. So it's a completely different scenario that we're looking at here. And Karen Read's team is making some very technical arguments with some of the claims here. And we're going to be able to compare it to some of the other cases that we have followed together and compare what worked in those cases and will it work here. We're also going to talk about some of the problems maybe with this complaint and what the lawyers can do to make it better, to make it continue forward. And always important when we're talking about civil cases and we're at the motion to dismiss phase of the case, everything written in the plaintiff's complaint, even though I know so many of you listening to this and so many of you out there do not agree with it and want to scream no collision, that's not going to be enough here, because in the motion to dismiss phase, every factual argument and statement made in the complaint is taken as true in a light most favorable to the plaintiff. So if they say in the complaint, Karen Read was drunk and hit John O'Keefe with her vehicle, the judge, when reading this motion to dismiss, is going to take those facts as true. That doesn't mean Karen Read's going to lose. It doesn't mean she's going to have to pay money. It just means if that is true, should I allow this claim to go forward? And that's an important picture to paint before we really dig into the claims that Karen Read has going here. So first, what is this motion to dismiss focusing on? Okay, these are the claims. Count 10. Negligent and or reckless infliction of emotional distress. Count 11, negligent and or reckless infliction of emotional distress. Count 12, negligent and or reckless infliction of emotional distress. And count 13, negligent, reckless, and or intentional infliction of emotional distress. So every jurisdiction is a little bit different. Florida, we wouldn't do it like this. It would be one claim for negligent infliction, one claim for intentional infliction. And if it was the recklessness, like you knew or should have known and you didn't really care, about the, you didn't really care about the actions you were taking and you knew it was going to cause somebody emotional stress, that could go under the intentional. But we don't really do the and or thing here because you have to either prove it was intentional or negligent. Here, they're kind of coupling these together. But if you notice, this motion to dismiss is focusing on those claims, the infliction of emotional distress claims, not the wrongful death claim, not the car accident claim. And I think that's important. And the plaintiff's response starts out something like Karen Read and her lawyers postured this motion to dismiss the entire complaint as if they were going to get the entire case dismissed. If that's true, and I'm sure Karen Read's lawyers, and we'll read some of the language in this, know that people are going to be reading this. People like me, people like you, they know people are going to be reading this. So maybe they'll put an eye towards that a little bit, but they'd be really stupid of them to think people are going to assume you're going to dismiss the entire complaint. And right in the beginning of their motion to dismiss, they focus on just 4 counts. So I don't really know there. Rebecca, thank you so much for gifting 20 Lawyer You Know memberships. 21, actually. I see the other one that you gifted as well. All right, let's read here. As a matter of law, The plaintiffs have not, nor can they, state a claim upon which relief can be granted insofar as any distress claims are subsumed by the wrongful death statutes. I don't necessarily know if I agree with this from Karen's defense team. I actually think I disagree with it. None of the plaintiffs can recover for negligent infliction of emotional distress based upon the occurrence of the alleged incident because they were not at the scene, nor did they witness the immediate consequences of the decedent. So what that means is they were not in the zone of danger, as we say. They were not in the impact zone. And we're going to dig into that more as we get into this complaint. But many times when you have the infliction of emotional distress claims that come along with other claims, you have to be physically there, almost seeing it or touching it, and it almost happening to you. A law school example is a mother sees her child get closed in an elevator door or hit by a car, or a boulder is dropping from a building and hits the husband who's standing right there holding hands with his wife. Those people are in the zone of danger. Those people are in the impact zone. I've had cases where a husband and wife are driving right next to each other. Wife gets hit over to the side, crosses the double yellow line, gets T-boned by another car. Husband sees the whole thing, runs out to care for his wife. Could have been him hit by the car. Those are the most appropriate negligent infliction of emotional distress. And Sleuthy Goosey brings up a good point. Well, they did see him at the hospital, right? That usually, it's going to be judge to judge. There's some judicial discretion and some differences in jurisdictions. Usually that's not enough. And the reason for that is courts, as you know, don't want to open the floodgates for these types of claims. And if every family member who saw a deceased family member at the hospital could have a intentional infliction or negligent infliction of emotional distress claim, that would be every single wrongful death claim. Every single wrongful death claim would also have these. Then we don't need them separately. That's what Karen's team is trying to say in point number one. We'll talk about why I disagree with that and why it's absolutely appropriate in some wrongful death cases to also have a negligent infliction of emotional distress case. The Boulder example that I gave you is one as well. But the reason, just because you see your deceased loved one, you are absolutely emotionally distressed. Nobody is saying you're not. The law does not usually allow for both of those claims, okay? But there are absolutely ways to have both, and we'll talk about that as well. The allegations in the complaint concerning the circumstances of the alleged accident and the defendant's purported statements and actions in the hours after the alleged accident cannot support a claim of intentional or reckless infliction of emotional distress. So what they're saying there is, even if everything you say in the complaint is true, you still don't have a claim. And that's how they have to argue it. They can't start saying, oh, this is wrong or that didn't happen. We may see some of that. The judge is not going to consider that. If they say there was no collision, judge, the judge is not going to care. That's not the time for this. I'm not the fact finder right now. I'm not trying to see what's been proven. We haven't brought discovery and done evidence yet. We haven't had a trial. Okay. So that's why they're not going to make those arguments. And if they do, they're not going to be successful at this stage of the case. All right, here we go. Relevant allegations in the plaintiff's complaint. The following allegations are taken from the plaintiff's complaint and are presented here in a light most favorable to the plaintiff pursuant to the legal standard. They should not be misconstrued as admissions by the defendant. And this is some of the stuff where I think, for everybody reading out there that supports Karen Reed, they don't want anyone to think we are agreeing with this judge. We are agreeing with what they're saying about Karen Reed. That's not what they're saying here. They want to make sure everybody knows the defendant vehemently denies that she is liable to the plaintiffs as there is no collision between the defendant's SUV and John O'Keefe. Guess what? This judge does not care at all about this paragraph. They realize that. That's how every lawyer is. That's how every lawyer is in this situation. And from my perspective, they're doing that for all of us reading it and to make sure nobody gets mad at them thinking, what? They think that's true? That's why I explained off the top, in this phase, that's the way the case is looked at. That's the way the complaint is looked at. Plaintiffs allege that on January 29th, between 12:11 and 12:36 at 34 Fairview, defendant drove her SUV and hit the decedent. We're going to kind of skim through some of the facts. I think we all know the facts. While under the influence of alcohol, plaintiffs allege he was knocked down on the ground and then the defendant fled the scene. And that's important to me. Fleeing the scene can lead to certain things. Plaintiffs further allege that approximately 4:30 a.m. at the decedent's residence, the defendant woke up the decedent's 14-year-old niece, Kaylee talked about the decedent's death and hitting the decedent with her SUV, and involved Kaylee in her frantic calls about the decedent's death. Plaintiffs claim that the defendant made telephone calls in Kaylee's presence during which the defendant commented, maybe I did something, maybe a snowplow hit him, maybe I hit him. Okay. So this is the first section that we're going to talk about how you could possibly get into the intentional infliction of emotional distress. And I will point you to, I got distracted there for a second because I actually want to check on one of our complaints that we filed recently. I just got an idea. So I'm going to point you guys to the not so distant past where we reviewed a civil case where the victim's name was Gabby Petito here in my home state of Florida. And she filed an intentional infliction of emotional distress claim against Brian, her boyfriend, who also ended her life's parents, for what they did and did not say publicly. And whether or not they knew what they were saying was a lie, like we hope Gabby gets back safe with her family. We want them to be reunited. So those types of statements that I think is a bit of a stretch, but they are in judicial discretion. The judge here in Florida allowed the case to go forward past the motion to dismiss. So I think if the O'Keefe's lawyers want to say that things Karen Reed said and did were intended to cause emotional distress, or she knew or should have known were likely to cause emotional distress, it could be a similar claim and theory that Gabby Petito had. Now, it doesn't seem like the plaintiffs did this perfectly or did great the first time around, so maybe this case will get dismissed and they'll be able to amend and bring it back. So from my perspective, if they can connect, she ran in, let me put it to you this way. If these facts were taken as true, could you start to understand how they get there? Karen Reed knew she just hit John O'Keefe and left, goes home, sleeps it off, wakes up, makes up a story, yells frantically, gets Kaylee all upset, all hot and bothered, starts saying things publicly she knows not true, starts blaming all these other people. It's putting the O'Keefes through emotional distress, and she knows it, right? That's the type of theory I think potentially they could have some kind of claim. Now, obviously, I don't think that's true. Obviously, I think they'd have an impossible time proving that when we go to trial and we hear, well, Karen Reed didn't just make that up. She has testimony from this person. She has the data from this phone or from this vehicle. She has an expert report that says X, Y, and Z. And when did she find these things out? And she has to know it's false, right? She has to have the evil intent there. She can't just be wrong. She has to know it's false. And that was some of the discussion around the Gabby Petito Brian Laundrie situation as well. What were their intentions? What did they know? When did they know? So just because I think they might be able to craft a cause of action that might get past a motion to dismiss does not mean I think it's going to be successful. But I do think there are ways where potentially we could see this build. Peter, need an attorney in POS fraud case, emailed Becca. Okay, I will try to take a look at it and see if I can get you somebody. Michelle, finally something you're qualified to speak on, Peter. Just a civil lawyer, Tragos. Haha, just kidding, just kidding. P.S. Sorry for constantly tagging you and all stuff. No, I love it. Ashley sent me links. You tagged me in it on Twitter. I love it. It makes sure I can get it. I don't always have time to go digging and find all this stuff. Sleuthy sends me stuff all the time as well. I appreciate all of the work everybody does in the background so that I can make it look easy on this show, because I know it takes a lot of time and energy from all of you. So I really do appreciate that. Susan C., thank you so much for gifting 5 Lawyer You Know memberships. All right. Plaintiffs allege that about 6:03 a.m. on January 29th, defendant observed the decedent laying in the ground, buried in the snow. Decedent was formally pronounced dead at the hospital. Hours after 7:50, the plaintiffs claim defendant appeared at the decedent's home, feigned comfort to his family, removed her vehicle, and destroyed relevant evidence. They further allege that the defendant knowingly and deliberately changed her story and fabricated a conspiracy, knowing the same to be false. So again, you have to prove this stuff eventually. But right now, the judge reads it as true. The complaint alleges that Margaret O'Keefe is the decedent's mother. John O'Keefe is the father. Paul is the brother. Kaylee is the decedent's niece. Margaret and Paul claim they came upon the decedent's body at the hospital. All plaintiffs allege that the defendant created a false narrative. So from my perspective, I will just tell you, I do not believe, as brutal as it is, and please hear me when I say this, I am not saying it's easy. I'm not saying this should ever happen to anybody or that we should poo-poo it. Seeing a deceased loved one at the hospital is brutal, and I don't wish it on my worst enemy. But I do not think that is appropriate for this claim. I don't think legally that's something that's going to be successful on this claim. Now, making statements and doing things publicly after the fact, that's why the wrongful death doesn't consume the claim, in my opinion, because they're two separate acts. If you're saying Karen Reed hit him with a car, okay, that's one fact. That's one scenario. And then after, if she did X, Y, and Z, those can be two different causes of action, in my opinion. I do agree with Karen Reed's lawyer that if they prove she hit him with the car, which I don't think they will be able to, but if they prove that, that should not be also an intentional infliction of emotional distress claim. And that's kind of some of the battle here. All right, defendant may move to dismiss a complaint if it fails to state a claim upon which relief can be granted. In evaluating the legal sufficiency of a complaint under this rule, the court must accept as true all of the factual allegations in the complaint and draw all reasonable inferences from it in favor of plaintiff. Nevertheless, the court need not accept as true any legal conclusions that are presented under the guise of being factual allegations. So just because, if I say I threw this ball up in the air and I caught it, right? That fact is assumed true by the judge. Now, what I can't do is say, and that, members of the jury, is a wrongful death of Jane Doe. It's like, no, you don't just take that legal conclusion and say that it's true because it's in the complaint. Nevertheless, the court need not accept as true any, okay, I already said that. To survive a motion to dismiss, a complaint must contain factual allegations which, if true, raise a right to relief above the speculative level and are not simply consistent with an entitlement to relief. Okay. So hopefully, as I'm kind of explaining it and giving you some examples, you understand what that means. Argument. The complaint does not identify the decedent past with a spouse or child, meaning the persons entitled to any wrongful death damages are the next of kin. Pursuant to the rule, the next of kin are the decedent's parents, Margaret and John. With respect to the claims that may be asserted on behalf of the decedent's parents as the next of kin, states in part, a person who, by his negligence, causes the death of another person shall be liable in damages in the amount of 1, the fair monetary value of the decedent to the persons entitled to receive the damages recovered as provided in Section 1, including but not limited to compensation for the services, protection, care, assistance, society, companionship, comfort, guidance, counsel, and advice of the decedent to the persons entitled to the damage recovered. Here, Margaret and John allegedly experienced emotional reaction to the caused by the death of their son. As the next of kin, their claims for loss of consortium are factored into the decedent's estate wrongful death claim and may not be duplicated as a part of any claim for emotional distress. Now, to me, this is differing depending on the jurisdiction. Sometimes it is, sometimes it's not. Emotional distress existing from circumstances other than the actions of the respondent or from a condition existing prior to the unlawful act is not compensable. The complaint fails to distinguish or otherwise delineate the alleged harm caused to Margaret and John between the loss of consortium and other emotional distress. So again, this may be a situation where an amended complaint, where they change and maybe add some facts, and they might be able to get there, but currently they're saying it's not. Watching from Australia with my 5-week-old baby. Those are the cutest babies. I love babies. I would watch your lives while pregnant and couldn't sleep. So special now to watch with her asleep in my arms. I wonder if she recognizes my voice. I've had people say, my baby definitely recognizes your voice and runs to the TV. I know she's not running yet, unless maybe she's a prodigy. Jen, I don't understand why John O'Keefe's family isn't more interested in going after the state police because of the horrible investigation. In my opinion, John O'Keefe will never have justice because of the investigation. I mean, I definitely think they would have a claim there as well. But we have to understand that they believe it was Karen Reed. I don't. I think the evidence doesn't point in that direction. I think it falls woefully short. They do believe that. So that's why they're filing this claim. Sometimes we don't always agree or see eye to eye. But that's why they're filing this complaint. Obviously, that's why they filed it, and that's why they're pursuing this action. Okay, plaintiff's emotional distress claim fails as a matter of law. All these counts, negligent and or reckless infliction of emotional stress without providing context for what conduct within each count applies to what claim. So this was a similar argument that I believe the laundry lawyers were successful on, and I think Gabby Petito had to go back and amend portions of her lawsuit. I could be missing that, but that's kind of what I remember. So that could be something that happens here. Even if it's dismissed, the judge says, go amend and try again. The elements of reckless infliction of emotional distress are markedly different from that of negligent infliction of emotional distress, because reckless infliction of emotional distress contains the elements as those for intentional infliction of emotional distress. I agree with that. Adding them together would not fly in Florida. So if Massachusetts is different, maybe it wouldn't fly in Florida. I don't think it should fly here. To prevail in a claim for intentional infliction of emotional distress, the plaintiffs must prove that the actor intended to inflict emotional distress, or that he knew or should have known that emotional distress was the likely result of his conduct, that the conduct was extreme and outrageous, was beyond all possible bounds of decency, and was utterly intolerable in a civilized community, that the actions of the defendant were the cause of the plaintiff's distress, and that the emotional distress sustained by the plaintiff was severe and of a nature that no reasonable man could be expected to endure it. And this is just the heightened level of this extreme emotional distress. It's not like Michelle said to me, I'm only a civil lawyer, and I say, oh, I'm so distressed, Michelle. I couldn't believe you did that to me. It's like, chill, bro. It's not that big of a deal. Your normal person would not be offended by that. It would not cause them emotional distress. You don't have a claim for IIED or NEID. Those are the acronyms. NEID is negligent infliction of emotional distress. IIED is intentional infliction of emotional distress. So they're just trying to define that for us. To prevail in a claim for negligent infliction of emotional distress, the plaintiffs must prove negligence, emotional distress, causation, and physical harm manifested by objective symptomatology, and that a reasonable person would have suffered emotional distress under these circumstances of the case. So that's another element that I haven't really touched on yet that I want to take a second and touch on. Sleuthy, it goes to your question earlier and many other questions in the chat. Seeing your deceased loved one is brutal, is miserable. A lot of people need and should go to counseling after. Most don't. For most of these claims to prevail in most jurisdictions, there's got to be something manifested inside you. Either you have anxiety, you can't sleep, you have to take medication, you go see a mental health counselor, you get a rash. There's something physically and mentally that's happening to you. You seek some kind of help or treatment for it. So you need that element. It can't just be, I was really sad, I went home, I went back to work, I went back, to my life, a hole in my heart, missing my loved one, but I went back on and grieved the best way I know how. The complaint's failure to specify the factual allegations in support of the different emotional distress claims warrants dismissal, or at the very least, a more definite statement pursuant to this Massachusetts rule. That argument aside, these counts appear to claim reckless infliction of emotional distress based on the defendant's alleged formation of a false narrative and the negligent infliction of emotional distress based on certain plaintiffs' observation of the decedent's body in the hospital. Joanne said, how long do the O'Keefes have to amend? That's a great question, Joanne. You guys are on top of it. This is up to the judge. The judge usually will say you have 30 days to amend or you have 20 days to amend. As far as statutes of limitations for the claims, they're good. They're locked in. It starts the day you file the initial complaint. Now, if they bring up a completely new cause of action, that statute of limitations is still going to run from the date of the incident. But as far as this, they have already locked in that statute of limitations because they've filed these initial claims, even if they have to amend multiple times, which sometimes it happens. Sometimes it does happen. And it's not going to be, this biased judge lets the O'Keefes do whatever they want. It's very common to let plaintiffs at least once, usually multiple times, amend the complaint. What page am I on here? I can't even tell on this. 7. Okay. Is it 30 minutes yet? We're not at 30 minutes. All right, we're good. No plaintiff directly witnessed the defendant's alleged negligent conduct, the alleged vehicle strike that is claimed to have occurred between 12:11 and 12:36 on January 29th, or the decedent himself until at least 7 hours after the incident. Massachusetts recognizes claims for emotional injuries by parents and close relatives arising out of their witnessing an accident to a loved one. But the plaintiff must show A, substantially contemporaneous knowledge of the outrageous conduct, and B, a severe emotional response. Only a bystander plaintiff who is closely related to a third person directly injured by a defendant's tortious conduct and suffers emotional injuries as a result of witnessing the accident or coming upon the third person soon after the accident states a claim for which relief may be granted. The close proximity of time between the alleged harmful event and the plaintiff's claim for emotional distress must be near instantaneous. And then they cite a case, a mother who learned of her son's passing by telephone 7 hours after the event, was not at the scene of the event, could not pursue a claim of emotional distress. And I gave you a lot of examples off the top that kind of explains that. Rebecca, I'm sorry, Peter. there is emotional distress with every death. I see that on a daily basis. Where is the line drawn as far as suing? Yeah, just because you see it, and I've tried to explain the line, it would be as if you're holding the hand or you're standing right next to somebody and they get hit by a car and you see it and it could have been you basically. You're in the car in front and their car gets smashed. It's got to be that proximity, and then you see them, you see the damage, you see the carnage. Usually, that's what it's for. Not you hear something horribly tragic happens and you go. I mean, every one of my wrongful death cases could have this element and this cause of action if it were just seeing the body of the deceased, which again is brutal, unimaginable. Why doesn't the nephew have a claim? Is it because he's a minor or he's part of JOK's estate? So to me, where they're talking here is they're trying to connect the people that Karen Reed spoke to right after, that's Kaylee, told this story to, or that went to the hospital and saw John O'Keefe's body. That's why I think the nephew is not included in these claims. But also, I can say sometimes people don't want to be in claims, or people think it's best to not involve them for one way or another, and that's their prerogative. Jessica said, wouldn't that be double jeopardy since she was found innocent for not hitting him with a car? So no, civil case and criminal case are completely separate. Now, if she would have been convicted, it would have been what we call res judicata, meaning already decided, and she would be the cause of his death, meaning the liability would have been all but sealed for Karen Reed. They still would have had to prove damages, meaning how much money she owed, but it doesn't go flipped because the burden is so much higher. So there are situations where a jury can find you not guilty because it's beyond a reasonable doubt, and then liable because it's not quite up to beyond a reasonable doubt, but it's higher than more likely than not, which is the civil standard, maybe 51% if we're going to put a percentage on it. So it's somewhere between beyond a reasonable doubt and more likely than not. So you can be found civilly liable, but not criminally liable. Yeah, absolutely. Karen was in her own distress, Michelle said. And I think that would be a great argument as well. Okay. Here, they allege that sometime after the decedent was transported to the hospital, at least 7 hours after the alleged vehicle strike, based on the factual averments, they observed their adult son/brother's body in the hospital. No allegation any plaintiff observed the alleged strike. Moreover, the plaintiff's claimed shock was not experienced immediately after the occurrence, but rather at least 7 hours later, removing it from the scope of the requisite temporal proximity. The complaint contains no allegation that the plaintiff, Kaylee, directly observed the alleged conduct that caused the decedent's death, nor did she observe the decedent at any point thereafter. And that's where I think the distinction with the brother comes in as well. The alleged perception of the death, as alleged, was based on conversations with the defendant, and there is no precedent for one to claim emotional distress as a bystander merely by learning via conversation that a loved one has been injured or passed away. Because the complaint fails to present a claim that the plaintiff's claimed emotional reactions occurred contemporaneously with the alleged tortious conduct or immediately after, their negligent infliction of emotional distress claims have no legal basis and should be dismissed. Plaintiffs each allege that the defendant outrageously created a false narrative. There are no allegations that the claimed conduct was performed by the defendant with such reckless design to cause emotional suffering to the plaintiffs. So here's what I'll tell you about this right here. So whenever a defense lawyer puts a statement like this in it as a plaintiff's lawyer, do you know what we usually think? Okay, judge, if we want to use magic words, we'll go back, we'll amend our complaint to say, creating this false narrative, she did it with such reckless design to cause emotional suffering to the plaintiffs. And that technically checks the box. We still have to go prove it, but it gets us past a motion to dismiss. So these types of arguments are technical ones that may be winning the battle but losing the war, or whatever that analogy is. But you still have to do it as a defense attorney. The defendant's statements in which she questioned and or denied striking the defendant with her vehicle, allegedly creating a false narrative, or speculated that a snowplow may have struck the decedent, do not rise to the level of intent toward the plaintiffs. So you got to be careful about arguing the facts aren't true versus if they are a outrageous false narrative, could it inflict extreme emotional distress? Moreover, putting aside that she was successfully defending herself against unproven and false criminal charges pending in Norfolk Superior Court, the plaintiffs claim that the defendant's conduct after the accident was extreme or outrageous fails as a matter of law. That finding that allegations of verbal attacks, filing false police reports, and harassment petitions did not rise to the level of extreme or outrageous, and the person bringing suit must show that the petitioning activities lacked any reasonable factual support or arguable basis in the law. So that to me sounds like a later argument, but they are absolutely correct that eventually the O'Keefes are going to have to prove that this false narrative is actually false that Karen Reed was talking about. Now, I think they would be better separating it from the actual car accident, and more, if they're really going to focus on this outrageous narrative, pick certain things she said in interviews or said to certain people and how she knew or should have known it was going to cause them emotional distress. Again, taking the Gabby Petito road, to me, the problem is that is still a weak case, a very, very weak case. I said it at the time for Gabby Petito, but there's so much momentum behind her. Everybody felt so horrible. They didn't feel like the full justice was gotten on Brian Laundrie. People still think Brian Laundrie's out there. It's kind of flipped in this case, right? All the momentum is behind Karen Reed. People think that she's innocent, factually innocent, and law enforcement screwed her over. And so just there's different optics to this case than Gabby Petito, but that's really, I think, their only shot at going forward on an extreme emotional distress claim. And by the way, just because they didn't try to dismiss the wrongful death car accident portion doesn't mean they're going to lay down on that. There's still a big fight to happen. Alan Jackson's on board. There's going to be a fight. I don't think Karen Reed is going to roll over. And they are going to try to clear her every which way they can. And summary judgment motions will come later, but that's different than a motion to dismiss. Liability cannot be predicated on mere insults, indignities, threats, annoyances, petty oppressions, or other trivialities, nor even is it enough that the defendant has acted with an intent which is tortious or even criminal, or that he has intended to inflict emotional distress, or even that his conduct has been characterized by malice or a degree of aggravation which would entitle the plaintiff to punitive damages for another tort. And this comes down to, how is the judge going to read this? How is the judge going to look at this? And we could have complete opposite outcomes here with the judge in Florida and the judge in Massachusetts looking at it, reading it, because these standards are very similar to ours, in my opinion. But we know how it came out that way. The complaint contains no factual averment that identifies the substance of the alleged false narrative and how it is outside the bounds of all possible decency to utterly intolerable in a civilized community, such that the plaintiffs may pursue an emotional distress claim. Yeah, if anything else, it's like, wouldn't your average person say, no, could I have hit him? I don't think I hit him. Maybe a snowplow hit him. To me, that seems like what everybody would say, what every reasonable person would say, and it wouldn't cause extreme emotional distress. So even again, if true, I really don't think it rises to the level personally. I really don't think this rises to the level if I was the judge. Without requisite factual averments, the complaint fails to present a cognizable claim for reckless infliction of emotional distress. Kaylee's claims. She asserts multiple claims for emotional distress, but does not ascribe what conduct applies to what type of claim. And this is like, again, a nuanced, you've got to separate it. You've got to make it clear. Plaintiff's alleged defendant spoke to a third person on speakerphone in Kaylee's presence, waking her up in the process, notifying her that something may have happened to the decedent, and inferring that Kaylee perceived the decedent's death. The plaintiffs also allege that the defendant feigned concern for the family and drove her SUV away from the decedent's residence after the decedent was declared dead. Finally, the plaintiffs again allege that the defendant created a false narrative for the reasons previously stated and set forth below. The complaint fails to state a cognizable claim. The defendant's alleged conduct identified in these counts, feigning sincerity and driving her SUV away from the property that the defendant allegedly did not own or control, does not rise to the level of the conduct that would be considered so outrageous and extreme that it would be considered utterly intolerable in a civilized community. I agree with you, but I also kind of thought that with the Laundries. I know we looked at that case differently and it was brutal, but you have to assume certain kinds of knowledge, and maybe they ended up proving that in the Laundries case. But here, you have to assume Karen Reed basically knew she hit John O'Keefe, knew she left him there to die, and decided to run in, wake up, scream, and tell Kaylee lies and continue to push lies out publicly. That's really the only way that you can ever, in my opinion, come anywhere near getting to an extreme emotional distress claim here. There's almost no chance, in my opinion, that they're able to prove that. But will they be able to put forth enough factual evidence to the judge to get past the motion to dismiss? Those are two separate questions. Moreover, the defendant's questioning what happened during phone calls with third parties. Okay, we already kind of repeated these things. Yeah, in conclusion, these should all be dismissed. Okay, let's take a second now here. Rebecca said, I had a 16-year-old put an end-of-life thing towards himself 2 feet in front of me. That being said, stuff happens, being devil's advocate, that I am. I understand, but it also, you have to have that relationship. It's not just any random person. You can't just do that. It's usually a close familial relationship, depending on, a number of circumstances. But yeah, generally speaking, that would not apply there. Oh, now it decides to work. All right, let me go here. All right, let's take a look at the response. All right, I'm going to read this introduction here just because I think it's kind of funny. Defendant Karen Reed inaccurately styled her motion a motion to dismiss the plaintiff's complaint, when in reality, it only seeks to dismiss several counts ending sounding in emotional distress, knowing that the media would pick up on the 9E filing. I don't blame them necessarily for, I don't blame them necessarily for coming out with that, knowing how this is going to be battled in the court of public opinion. Oh, I see Tim Sullivan here. What's up, Tim? So I'm going to assume this is lawyer Tim Sullivan, not MRI Timmy Sullivan. I don't know if that's true or not, but lawyer Tim Sullivan. So we're going to do a video in the future talking about like law school and early years and going to undergrad, because a lot of people have questions about that. And when I tell you about trying cases against really good private defense lawyers very early on as a prosecutor, Tim Sullivan was one of those lawyers. I won't say the outcome because he's here and I love Tim and respect him. So I won't say what the outcome was, but learned a lot trying cases against lawyers like him when I was on the other side. Okay. And if it was Tim Sullivan, I can't wait to golf to him. He's a sweet swinging lefty, Tim Sullivan. So those are the two Tim Sullivans in my life. And I had to change their names in my phone, one of them to Timmy Sullivan, just so I wouldn't accidentally text the wrong one. All right, let's get back to this. So, all right, we're going to skip the factual allegations. Again, we've read them over and over again. Oh, it's the golfer Tim Sullivan. Okay, golfer Tim Sullivan. We go by Timmy. You go by Timmy in my head, Tim. Okay, so we're going to get down to, all right, I want to mention this just because a lot of people were talking about it. Karen Reed and her family went through great lengths to obtain orders from this court, shielding them from convening discovery in this civil action during the pendency of the criminal matter. So she says things like, or the O'Keefes say things like, oh, it's so inappropriate. They're trying to block discovery. They don't want to let us take depositions. They won't allow this. And from my perspective, you can say that, and it is true that they were trying to block discovery, but it was completely appropriate, completely legal, and what you should do when there's an active criminal case. So the judge is not going to care. Again, if they crossed out a paragraph of Karen Reed's document, the judge is going to cross this paragraph out too. They don't care. The judge is the one that made the decision to stay. So obviously the judge does not agree with you here. The judge agrees with them. But again, they threw it in there because they're trying to take shots. Okay, the only issue that this court needs to resolve today is whether, assuming all factual allegations to be true and indulging every reasonable inference in the plaintiff's favor, the complaint plausibly suggests that the plaintiffs are entitled to relief on the infliction of emotional distress claims. The answer to that question is a resounding yes. As will be demonstrated below, there is no bright line test for the plaintiff's infliction of emotional distress claims. I agree, but there's kind of like a baseline. Each claim requires an independent factual analysis on a case-by-case basis, which cannot be resolved at this stage of the lawsuit and without adequate discovery. So here's where it bites them. When you have the facts that are assumed true, you have to still put in enough facts. You can't just say, we'll get those facts in discovery, Judge. It's not how it works. You don't get to do fishing expeditions as a result of filing a claim, or guess what would happen? If you don't like somebody, you can just sue them, dig into discovery, get all their financial information or private information, and then be like, oh, okay, I found some facts I can sue them on. So that's backwards. You can't do it that way. You have to have the factual allegations upon information and belief. You don't have to have all the evidence yet, because a lot of times you don't have access to all the evidence until you do discovery. But you can't say, oh, Judge, just let us go in discovery and then it'll be better. And then it'll be better. In civil cases, what are the grounds for appeal? There's tons of grounds for appeal. I'm not able to just go through any individual one, but very similar to a judge making a horrible decision, or a lawyer lied or hid something, or ineffective assistance of counsel. There's lots of grounds for appeal. Rebecca said, happy birthday, Deb. Happy birthday to Deb. And as a gift, she's gifting 5 more Lawyer memberships. Thank you, Rebecca. Rebecca is defending her fantasy football title in the Lawyer League. Okay, whether the O'Keefe family suffered shock closely on the heels of Reed's actions and JJ's death, and whether Reed's subsequent conduct rises to the level of extreme or outrageous are questions prematurely raised to this court. I do agree with part of that, was it extreme and outrageous enough? The court just has to see if it's enough to get over the line, not to actually prove the case. Okay, relevant factual allegations. They focus on the fact that she had at least 9 alcoholic drinks. She was so drunk. She was inebriated, still inebriated after the fact, still inebriated here. They really focus on that. But again, we know what happened in the early morning hours. Then she began to devise a false narrative of the events in the interest of self-preservation. So here's the problem. When you go with that theory and theme, you kind of, in my opinion, I've never had this happen in a case, but if I was Karen Reed's team, I would tell the judge, if this is the claim they're going to make, then we, judge, want the fact that that false narrative was portrayed and argued to a jury of Karen Reed's peers, and they agreed with it, and they acquitted her. So all those jurors are just in on the false narrative, kind of flip the script on them. I would ask for that to come in. Now, generally, that would not come in a civil case, the fact that she was acquitted. And so from my perspective, I would try to do that. Because what do you think a jury would think? Because I think a lot of you who asked the question, isn't this double jeopardy is what you're calling it, but what you mean is, hasn't this already been decided? Why is this here? I think if a jury found out that Karen Reed was found not guilty in a criminal trial, they'd be like, why are we here? So I'd love to put that in front of them, which is in fact the prejudice and why it's not usually allowed in. But if they want to make this argument that it's a false narrative, I'd try that. At around 6 a.m., she returned to Fairview. Okay. Her actions at the hospital resulted in severe emotional distress. Okay, so we know the facts. We know the facts. Argument. As discussed further below, this honorable court should deny Karen Reed's motion to dismiss because the allegations in the plaintiff's complaint, taken as true and construed in the plaintiff's favor, state claims for relief that are plausible on their face, and plaintiff's infliction of emotional distress claims require a fact-intensive analysis, which is not ripe for deciding at this early stage of the lawsuit and without adequate discovery. A plaintiff should prevail in a motion to dismiss under this rule if the factual allegation in the complaint assumed to be true. Okay, we already read all this. This generous and indulgent criteria have reduced a plaintiff's obstacle in surmounting a failure to state a claim. So basically, the plaintiffs, and this is not embarrassing for them. Some people may think it's embarrassing. This is what I would do too. It's what you should always do. This is what I try to do to a jury in civil cases. I'm like, beyond a reasonable doubt is way up here if I'm the criminal defense attorney. And if I'm a civil plaintiff's attorney, I'm like, but just more likely than not, it's way down here. Way down here. It's kind of like the genie in Aladdin where he's like, great big power, itty bitty working space, right? It's like, we've got all this evidence, but our burden is way down here. And that's exactly what they're doing to the judge who already knows this. But just as a reminder, judge, our burden is very low. Our burden is very low. Sorry, Peter, we're all rooting for Rebecca this year. Skull Vikes. You want a back-to-back champ? At least pick somebody else. Root for the underdog. Me and Rebecca are the only 2 champions of the Lawyer You Know League. Peter, I'm a lawyer. I've always looked up to you. Can I be on your show? Love Mike Pernick. For anybody that's going to say, oh, how nice and sweet of Mike. Mike is a friend of mine, also a lawyer in this area. So instead, I think give Mike a rib. Why don't we take a shot at Mike? A nice one, but a shot at Mike Pernick. All right. As a preliminary defense, the defendant Reed argues that JJ's parents, Margaret and John, are precluded from asserting claims of negligent infliction of emotional distress claim against Reed because any emotional distress claims arising from the NEID claim would be duplicative of the loss of consortium damages available under the wrongful death statute. Reed, however, cites no applicable case law to support her argument because no such precedent exists. Okay. And this is kind of what I've already gone over. I agree with the O'Keefe family that it doesn't consume all emotional distress claims. But I agree with Reed's team that it does consume some. We don't need to read all that, though. All right. Defendant Reed cannot demonstrate that she is entitled to relief under Rule 12 as a matter of law based on the pleadings alone. Defendant argues that the O'Keefe family's shock from experiencing and witnessing the consequences of Reed's negligence was not sufficiently contemporaneous. I just lost my space. To support a claim for NEID. Although courts have imposed relational, temporal, and spatial limits on the scope of liability for emotional harm in this context, there's no bright line test. So basically they say, respectfully, we disagree with your analysis and argument. I asked a few weeks ago and you said you needed to think about it, but I'll ask again. Will the fact that ARCA was hired by the feds be allowed in the civil trial? I think the answer is no, because that would open up the door to talking about the criminal cases, and getting into the same issues of explaining, okay, there was this state investigation, there was this federal investigation, and then we have a trial within a trial potentially. If I was O'Keefe's lawyers, I would argue against that because that's going to take a lot of time. It's going to cost a lot of money for us to bring and kind of litigate that issue. So if we don't open the door, it shouldn't come in. I would guess no, but I would still argue for it to come in if I was Karen Reed's lawyers. Okay. Margaret John Sr. and Paul's NEID claims. They try to draw an arbitrary line. There's no requirement the shock must be immediate. Yeah, but it's pretty close to immediate. A plaintiff who rushes on to the accident scene and finds a loved one injured has no greater entitlement to compensation for that shock than a plaintiff who rushes instead to the hospital, so long as the shock follows closely on the heels of the accident. The two types of injuries are equally foreseeable. Now, I did not read this entire case. I'd like to, because again, I do not think that generally, if you rush to the hospital to see a dead loved one, that you would have an NEID claim, personally. Holding that the trial court erred in granting summary judgment for the defendants on the plaintiff's NEID claim, where plaintiffs first observed the family member's injuries upon arriving to the hospital, not at the scene of the accident, because on summary judgment, it may be inferred that the shock occurred immediately following the accident, superseded by the statute on grounds. Okay, so again, this is the shock occurred immediately following the accident. That's something I think is distinguishable from this case. In Zachary, a nurse negligently injected the plaintiff's father with an unknown substance, causing him injury. While the plaintiff's daughter learned of her father's injury the same day via telephone, she did not observe her father's suffering in person, nor learn of the nurse's wrongdoing until the following day. But did she observe her father's suffering in person? Again, I think that's different here. Acknowledging that the issue was a close one, but the court denied the defendant's motion for summary judgment and permitted the plaintiff's NEID claim to go forward. To me, this is an easy call. It should just absolutely not be. I did not read in Karen Reed's response or in their initial motion to dismiss that this would open the floodgates. And judges usually hate to open the floodgates. But if this was the case, every accident case I have in Massachusetts, which I do have some in Massachusetts, could also have an NEID claim. Not every accident, but wrongful death cases, etc. Peter, will the civil trial be televised? So Alan Jackson said he didn't think so. But he also said people hadn't asked for it. So I think it's possible. I don't think it's a guarantee. Rhonda, have to say, I love that you admit you are bad at famous sayings / one-liners. So am I, but it's hilarious that you always quote movies. I love one-liners and I love movies, but I'm so bad at quoting one-liners. I'm okay at movie quotes. I'm okay. I'm bad at music lyrics. Even though I feel like I know a lot of songs, I'm bad at music lyrics because I just put in my own lyrics in my head that like kind of go on beat and are similar. And then I just run with them and think of them as true as I go. All right. All right. Collision between Reed's SUV and JJ occurred sometime around 12:30. She left JJ helpless and seriously injured. Instead of calling for assistance while he lay there suffering and freezing in a blizzard-like condition. By the way, the fact that John O'Keefe was alive and suffered, if they can prove that, that can be additional damages in these types of claims. We'll probably hold that for a future video, but that's always a big deal. Was it an instantaneous death or were they able to feel and suffer? Because obviously, if you left them there suffering for hours and hours, that's additional claims for the estate. In certain jurisdictions, it's allowed. It was approximately 6 a.m. that Reed returned 34 Fairview with emergency responders. It was around that time the O'Keefe family immediately learned of his injuries and admission to the hospital. The O'Keefe family rushed to the hospital, came upon his body only minutes after he was pronounced dead at 7:50. It's abundantly clear from the circumstances where, when, and how the injury to JJ entered into the consciousness of the family that the shock experienced by the O'Keefe family followed sufficiently closely on the heels of Reed's alleged wrongdoing and the consequences to JJ to state a viable claim for relief for NEID. I disagree, but that's their argument. Kaylee, we know their argument here. Okay, the defendant's argument fails to consider the totality of the circumstances presented here, the when, where, when, and how to the injury. To the injury entered the consciousness of Kaylee. While Kaylee may not have witnessed the initial collision, which resulted in JJ's injuries, she experienced firsthand the trauma, panic, and chaos that ensued shortly thereafter within 4 hours of the collision. And amid Reed's sustained wrongdoing, a vulnerable 14-year-old who had already lost both of her parents tragically was abruptly awakened at 4:30 by hysterical screaming. Karen Reed talking about hitting JJ with her SUV, involving Kaylee in phone calls about JJ being struck by a snowplow, and proclaiming that Kaylee's surrogate father, whom she had come to depend on, was dead. So here's what I'll say. It was a good strategy for the O'Keeffes to explain that Kaylee is somewhat of an eggshell plaintiff. She is susceptible to this extreme emotional distress because she has gone through things that 14-year-olds should never have to go through, and they shouldn't have to go through it once in their life, and she's been through it multiple times. Up to 3 times, losing a loved one and the person responsible for her. Unimaginable. So I do understand that and bringing that in, that she was vulnerable. Notwithstanding the fact that Kaylee did not physically observe the collision or John's body, Kaylee witnessed firsthand Reed admitting her wrongdoing and simultaneously perceived and experienced the gravity of her harm caused by Reed through a sudden and overwhelming onslaught of sensory stimulation and invading her consciousness. I just don't think that that's legally appropriate. I think that would open the floodgates, like I've been saying. Now, to say she lied and created this false narrative and did it to hurt Kaylee and the family and everything she was putting out there to poison everybody, if true, then I could see how we start building something, but I really don't see these facts as even rising to the level of allowing them to go forward, but I don't know. All right. Viewed holistically, suggests the O'Keefe family is entitled to relief. Again, I think this is kind of weak, but whenever you have to say like viewed in the totality or holistically, that's how we get there. The defendant disregards the totality of the circumstances that all reasonable inferences construed in the plaintiff's favor. The critical question is whether the claim, viewed holistically, is made plausible by the cumulative effect of the factual allegations contained in the complaint. Requiring highly specific facts within the complaint is misplaced at the pleading stage and is reserved for summary judgment in the trial. So I'm glad they did this because they're right. You don't have to be highly specific with your facts, but you absolutely have to be specific enough that the defendant knows what they did, what you're alleging they did, what statements they made, what actions they took that rose to this extreme level. You can't just be basic and be like, you were mean and it caused me distress. What did I do that was so extreme, especially when you have cause of action like this, which, by the way, these emotional distress cause of action, everybody thinks they have one. If you read them, it sounds like it would be the most common cause of action ever pled. I don't know if Mike is still in the chat. They're rare. We don't normally file them. When we do, it's because something very specific happened, and we know we can prove it with what specifically happened to our client in that situation. As the court emphasized, notwithstanding the notoric plausibility standard, no detailed factual allegations are required in the complaint. Go Cowboys. Thank you for those backing Team RN Medics. See, Peter, girls can do it all. And you're a girl, Dad. I love it. Yes, yes. I would definitely not disagree with that. In evaluating whether a defendant's conduct was extreme or outrageous, the court should not isolate individual incidents, but rather should draw reasonable inferences from the totality of circumstances, including whether the individuals at whom the conduct is directed is known to be particularly susceptible of infliction of emotional stress. I agree with that. Further, the court should put as harsh a face on the defendant's actions as the basic facts would reasonably allow. I agree. And that's the hard part is like, even with that standard, do we get there here? And you guys let me know. Let me know in the comments. Let me know in the chat. Do you think if everything we're saying is true, which I know you say it's not a false narrative. I know you say Karen Reed, was defending herself or she was in distress too, but put all that aside because that's what a judge has to do. Assume it's all true. Assume she hit him with the car, left him there, came back, said this stuff later to Kaylee. Does it rise to that level? Or is it reasonable? Is it what anybody would say? Is there no way, and here's the other thing, is there no way to tell Kaylee John O'Keefe is dead that's not going to cause her extreme emotional distress? Because that's something you have to consider too. If there's no way to say it without causing extreme emotional stress, same thing with the O'Keefe parents seeing him deceased. That's always going to cause emotional distress. So what is unreasonably extreme about this that Karen Reed did? Let me know what you guys think in the comments. There is an issue for the jury if reasonable people could differ on whether the conduct is extreme or outrageous. Right. And this is important. Words are important. Definitions are important. If reasonable people could differ, Can they differ with what we're talking about here? And if the answer is no, then it's got to be out. Okay, Kaylee's intentional claims here. Knowledge of vulnerability, very similar arguments made. They talk about Karen's relationship with Kaylee leading up to and including the time of her wrongful conduct is a key factor. They go back to, intoxication, leaving him seriously injured. Reed deliberately involved Kaylee. Okay. But again, she has to know what she's doing is wrong and is causing distress. Not if you can prove that Karen Reed's motivation was to try to figure out what happened to John O'Keefe, this all falls apart. So factually proving this to a jury is going to be very difficult. Peter, can materials from the criminal case be used? If by materials you mean documents and depositions and witness statements and expert reports, absolutely. Absolutely, they can be used. Rebecca, okay, being serious, I do not believe that John O'Keefe and his loved ones are ever going to get closure on this, whether it be from the investigation or what actually happened. Sad all around. I agree, but I understand them trying to get it in this civil process. I understand that. Even if I disagree with the outcome and what actually happened in this case, I get it. They're in an impossible situation. I think they're trying to do what they think is right. I do. Karen Reed deliberately involved Kaylee in her plan to cover up her involvement by calling various acquaintances in front of Kaylee, proclaiming, among other things, that JJ never came home and that he may have been hit by a snowplow. Well, he didn't ever come home. And I guess as we sit here today, he may have been hit by a snowplow. Nobody's actually proven what he's been hit by. Knowing that her words and actions caused Kaylee severe emotional distress, Reed then stranded Kaylee home alone, shocked and frightened with no one to confront her. So again, are they going to be able to prove that leaving and going to try and find and help John O'Keefe was extreme and outrageous conduct to cause her emotional distress? Because you can write the story the way you want to in your complaint as a plaintiff. But there are lines, there are boundaries here to this claim. In drawing all reasonable inferences from the totality of circumstances here, including Kaylee's age, vulnerability, and relationship with Reed, and in placing a harsh face on Reed's actions as the basic facts would reasonably allow, it is clear that the reasonable people could differ on whether the conduct is extreme and outrageous. So even they say reasonable people could differ. I would like to argue, and usually in my cases, I say, Judge, everybody would agree. Nobody would disagree that this is extreme and outrageous. And again, I do think leaving somebody there, if you hit somebody and you flee, I think that's intentional infliction of emotional distress as well. You're leaving them there. You know you're going to cause them emotional distress. You choose to do it. But again, that doesn't affect the family members. Okay, now their IED claims, they say it's premature. Give us more discovery, Judge. Let us argue this. It's plausible. Cumulative effect. These are all things that infer to me that it's weak. It's weak. We need all reasonable inferences. This is weak. First, there's no requirement that Reed intend her post-incident statements and conduct to cause emotional distress to the O'Keefe family. Although denominated an intentional tort, a review of decisions in which the cause of action has survived, a motion to dismiss indicates that the majority of such actions are based not on conduct engaged in for the purpose of causing distress, but on conduct which the actor should have known would result in distress. Telling him John O'Keefe's dead, trying to figure out how, leaving to try and go find him or help him. Should she have known that would result in distress? And it's like, let's say something horrible is happening to somebody, and I'm about to barge in the door and save them, and their family member comes up. Do I not tell them, hey, I'm about to go save your child or your loved one because it may cause them distress that I'm about to go save them? We have to be realistic here. We have to be logical. That's how the law is put together. Rebecca said she agrees with me 100% this time. This time. It doesn't always happen. The SJC noted that while many of her allegations are not particularly well stated, that's never good as a lawyer that you want to hear. We believe that the plaintiff has alleged facts and circumstances which reasonably could lead the trier of fact to conclude that defendant's conduct was extreme and outrageous, having a severe and traumatic effect on plaintiff's emotional tranquility. So again, these are the things that drive defense attorneys mad. It's like the bar is low. It's kind of like probable cause. When we talk about criminal cases and a lot of you guys get frustrated, it's like the bar is low. Let me explain to you just how low this bar is. It would be highly inequitable for this court to dismiss the O'Keefe family IID claims for want of specificity at this stage, whereas Karen Reed holds the keys to the evidence needed to prove those claims. Yet Reed has gone to great lengths to shield the evidence in discovery. So this is not true, okay? So they may need what Karen Reed has to prove what they say is a false narrative is actually false. They may need what Karen Reed has to prove what Karen Reed knew. But you know what they don't need? They don't need anything from Karen Reed to prove how I was emotionally distressed. What did Karen Reed do to me that caused me severe emotional distress? I should be able to explain that to you. Kaylee and Karen Reed were in the same room. It can't cause Karen Reed emotional distress what Karen told Carrie at the scene, because she wasn't there. She doesn't know about it. So they should have the information to be specific enough to get past a motion to dismiss. The stay of civil proceedings against Reed has only recently been lifted, and the subject motion was served before plaintiffs had any meaningful opportunity to conduct discovery regarding the very claims Reed seeks to dismiss. So there's nothing that says you can't file a motion to dismiss until all discovery is done, obviously. So this is, again, a losing argument for them. There's some that I agree with, but that's not one of them. The imbalance between the parties is precisely why generous and indulgent criteria have reduced a plaintiff's obstacle in surmounting a failure to state a claim to a minimal hurdle. What I'll also say is civil plaintiffs' attorneys are not usually like prosecutors at all. I think they're going to fight a lot harder than we saw any prosecutor fight in this case. It's just my guess. Unless they totally give up on the claim, they may just bow out. The requirement of plausibility on a motion to dismiss simply calls for enough fact to raise a reasonable expectation that the discovery will reveal evidence of the illegal conduct. I agree, and I'm not sure you've gotten there with this statement. While the plaintiffs believe that the discovery from Reed will substantiate and expand on their claim for a false narrative, a public filing from Reed's criminal matter lends support to plaintiffs' IIED allegations. According to the investigation of Detective Lieutenant Brian Tully, they're going to have to rely on these people, by the way. Good luck with that. By the way, we're over an hour. We're almost done, but we are into overtime. We haven't done overtime lately. So everybody hit that like button for me for overtime. If you're still here, hit the like button. Let's keep going. Following her arrest, Reed began using an old friend as an intermediary to covertly share information about defense theories in her criminal case, a well-known blogger via encrypted messaging applications. According to Tully, Reed began to secretly and selectively filter non-public information to the blogger for publication, including evidence, personal witness information, defense conspiracy theories, FBI involvement, and the impanelment of a federal grand jury. Reed eventually began communicating with the blogger directly and allegedly controlled what content the blogger would publish on his platforms at various points in time. The blogger made public comments about influencing Reed's jury pool, arresting the people who killed John O'Keefe, and inferring during a rally that the O'Keefe family's period of grief had expired and they were now fair game to try and send an innocent woman to jail for the rest of her life. So they are very clearly going to try and use the Turtle Boy situation to poison whoever's listening to this case, judge or jury. Now, they're making some very serious allegations. Will they get the evidence to prove these things? We'll see. But this is not really the same argument they were making. Her coming in and saying to Kaylee, maybe I hit him, maybe a snowplow hit him, is not this argument. So I think at the very least, they're going to have to amend this complaint. I really do. Without repeating relatively minimal threshold for overcoming emotional dismiss, yes, please do. Reed knew or should have known that she would cause severe emotional distress to an already grieving family. The plaintiffs acknowledge that the circumstances in this case are exceptional and certainly distinct from any of the IED cases relied on by the defendant. Yeah, that's usually not good for you. That's usually not good for you, which only favors the view that a Rule 12b6 motion is improper means to challenge the O'Keefe family's IED claim. A jury, not this court, should resolve whether Reed's conduct was extreme and outrageous under the totality of the circumstances in this case. So why is this important? If it can go forward to a jury and the judge does not throw it out, this gives them a lot more leverage against Karen Reed to potentially make her settle. This is also a situation where maybe Reed's team proves no collision like they did at the criminal trial. But Maybe they can argue to a jury what Karen Reed did, the way she acted, the way she did these interviews, the looks on her face, whatever. In today's day and age, who knows? All that stuff she did, the Turtle Boy stuff, caused us extreme emotional distress. Maybe they still win on this claim even without proving a collision, because it is technically possible. I don't think it should be. I don't think they will, but technically and legally it would be possible potentially for them to win on an IIED claim or an NEID claim based on her statements long after the accident, even if they prove there was no collision. And when I say accident, I mean something maybe accidentally happened to John O'Keefe. I don't know what it is, not necessarily a motor vehicle collision. I'd go to the mat instead of settling this. Yeah, I've always thought Karen Reed would settle, but once she brought Alan Jackson on, my mind has had somewhat of a change to where maybe she won't settle. Most of these cases settle, so that's usually where the good money is. But when you bring on Alan Jackson as a hired gun of sorts to try this case for you, a guy that's a criminal lawyer, he is a criminal lawyer. Bring him on to the civil case. Criminal lawyer, civil lawyer, it don't matter. You're a trial lawyer. You're going forward on this case, and maybe she fights it. Maybe she fights it all the way to the end. Rebecca, again, devil's advocate. How am I not sued for inflicting emotional distress when I tell a family member that their loved one is gone? Well, it's not your fault they're gone. So that's what they're trying to connect here. I'll tell you what, in medical malpractice cases, the way doctors handle those conversations after can be part of it. Peter, what determines judge or jury in civil? The parties. This is going to be a jury trial. Big Apple Hoosier, I was summoned for federal jury duty in South Florida. I can't wait. But I got no one ever answers the phone at the office. LOL, double duty. No, you're not going to have to do double duty, but yeah, you're going to want to figure that out. If you show up when the first date that you have, you can tell them there, they'll get it sorted. But, the government moves slowly sometimes. Jen M, I didn't want them to think anything terrible had happened, but something terrible had happened. Yeah, there's going to be a lot of this coming. Karen gave a mouth-to-mouth CPR to John, vomit and blood-covered mouth. No killer did that. Then had brainwashed O'Keefe's accuse her of hitting John. Yeah, and again, the factual allegations, what happened, what didn't happen, that's all coming later. Right now, that's all, even if assumed true, can they get past this motion to dismiss? That's the big question. All right, folks. That's all we got. Let me know if you guys have other things. A bunch of you send me this. If there's any other civil documents you want me to break down, we can absolutely do that. If there are other cases you're following, don't hesitate to reach out. I appreciate you guys so much. Make sure you hit that like button. Please make sure everybody is subscribed to our channel. For now, that's all we got. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.